Residential security deposits, here's what we know. If it's interest-bearing, we got to disclose it and the rate. Residential. We talked about the distinction with commercial. It's not supposed to exceed double the monthly rent unless the rent exceeds $2,000 a month, $2,001. Okay, different classification. Also, upon termination, accounting, we talked about this, got to give it back to them within 14 days, no problems. If there's damage, you got 30 days, or if they didn't give proper notice. That can also occur, but otherwise, get them back 14 days if no damage occur. Otherwise, they could come back to you for double damages. Residential.
Some of like we have the ones we manage, and then we have some that we just assist owners to find tenants, and then they manage it themselves.
Sure. Charge a rent-up fee.
One of those, the owner, when we were going through the lease for him to approve it, he wanted me to change the 14-day to 30-day. It wasn't like the if this, then this, but it was just, he said, yeah, change that to 30. I mean, we don't manage it, so I mean, it was just one of those things, okay, this would be on your liability, you know, if it were to go to court.
Guess who's going to get named in the lawsuit?
That'd be us.
Yeah. They're going to go after you, too. So at the point where the owner says, break the law for me, would ya? You go, I'll give you a blank form. You want to scratch that out and have them sign it or whatever, that's one thing. But as a professional licensee, I don't break the law because if I do, I could lose my real estate license. Oh, I got you. I got your back. No, you don't. It's like the seller on a piece of property telling you you're going out on a listing appointment. You say, and they tell you, go ahead and run all the red lights and get here quick. And you go running through a red light, the cop pulls you over, you go, what do you think you're doing? I was right there. You go, yeah, but the owner said I could break the law. The owner doesn't have the authority to tell you to run a red light. So it's like, no, I'm not going to break the law. Can't break that.
We also give notice on residential on that accounting within 14 days, 30 days of damage. If it's going to be longer than 14 days, we give them a notice and advise them that we have found damage. It will take the 30 days or however many days depending on the damage.
Right.
So that they can't
give you cover on that. So it's like, oh, you had to get back in 14 days. See, the old law was different than the new law when we added some of those revisions to it. So if they've done some damage, let them know. Hey, it's going to take another couple of weeks because we've got to get some estimates and things like that because of the damage. We're just informing you that the 14 days is out the window. Terms and conditions under which the prepaid rent or portions of them can be held. We'll talk about that. Within the agreement, property transfer, if I'm selling it, the new owner has to recognize and document that they've received the deposits. If they don't do that under residential, then the earlier owner could be held responsible for paying back security deposits under residential. A landlord may not demand, we talked about this, 2 months periodic rent unless it exceeds. So this is the statutory reference that addresses that. This is one that could be changed unless requested by the tenant. You know, I think it's time to modernize this a little bit. It's also time to start talking about electronic fund transfers in trust account procedures because the trust account laws were written 40 years ago. Before the internet was being used and electronic fund transfers were there. It needs to be updated. 40 years later, we could address some modifications. Upon termination of the tenancy, property money held by the landlord as prepaid rent or secured deposit may be applied to the payment of accrued rent and the amount of damages that the landlord has suffered by reason of the tenant's non-compliance. So when they say, well, you can't use that, that's last month's rent. Apparently you haven't read 3403070. If I've got your money, I can apply it to whatever I want. The law allows me to do that. So it's not just restricted for damage or last month's. I can use the money either way under 03070. They got to be itemized, got to get that back to them quickly. Address, time limit prescribed, we talked about that. In the subsection, damages means deterioration of the premises and, if applicable, the contents of the premises. However, does not include deterioration, i.e. you can't bill for wear and tear, as I've mentioned a couple of times. They say it's wear and tear, you say it's damages or cleaning. So, you know, there's a gray area there. So to the degree we can narrow that down, we minimize some of our exposure, or caused by the landlord's failure to prepare and to do the stuff that they're supposed to do. All money paid by the landlord by the tenant's prepaid rent or secured deposit in the lease or rental agreement shall be promptly deposited by the landlord wherever practicable in a trust account. So residential says that if the landlord does keep it, because they may not even be using a real estate person, but if I'm a landlord and I've got rentals, the Landlord-Tenant Act says I'm supposed to put it into a trust account, regardless of whether I'm licensed or not. They could hold it with a licensed escrow agent. Not a lot of savings and loans around after the debacle of '86 when all 14 of them that were in this state went out of business, so there aren't any here in Alaska. Landlord has to provide the tenant the terms and conditions under which the prepaid rent or security deposit may be withheld. So this is one of those modifications. Is they'll say, hey, these are the basics. If you tore it up, did some damage, then we're going to be able to keep it, and that there are some other stipulations. It doesn't say that I can't mix the prepaid rents and the security deposits in the same account. Karen?
So do you have to provide them, these are all the different ways that you could not receive it back before the, or in the lease agreement or after the fact?
I'd put it into the lease agreement, so then it's clear right up front. If you do any of this crap, we're going to use the money and apply it.
Most creative ways of doing stupid shit.
Well, I know it, and that's why, here's what we know. If I put, these are the 27 reasons why we will take it, they're going to argue, well, this is kind of between number 14 and 15. But you know what? It's really about narrowing the window down so that if I get pulled in front of a judge, small claims, and they're trying to make some lame excuse, and the judge says, there's 26 things here that say if you do any of this crap, they're going to take your money. This seems pretty definitive. Did you make a good faith effort to try to clarify to this consumer that this would be grounds for keeping the money as opposed to, well, if you screw something up, then we're going to keep it. So I think the more detail that we have in that, especially with the judges that tend to favor the tenants a little bit and give them a little bit of room, we're not going to necessarily close the door completely as far as exposure, but we're really going to make them have to dive through a pretty narrow, because what's reasonable? The judge looks at that and says, you know what, this is pretty comprehensive. They really are within their rights to take it. You screwed up. If the landlord willfully fails to comply, here's where their recourse is. If you make the wrong call, they could get twice the money back. And so we want to kind of narrow that down as much as possible. Otherwise, we're going to have some exposure. If they give notice, you got 14 days. If it hasn't been torn up, hey, you walk in, it's perfect. No problem. So I got to get that money back within 14 days. If they haven't beat it up, they've given proper notice. The 14 days is still out there. It's been changed if there is damage on it. Tenant doesn't give notice, then you got 30 days. Or if there's damage, you've got 30 days under that circumstance as well. So this is one of the new modifications. The condition of delivery of the possession of the premises to the tenant, the landlord may require the tenant to acknowledge or verify the tenant's signature, the accuracy of the premises condition statement and contents inventory prepared. So you would presume that they would know that, but you're putting it in there to say, hey, all this detail means that we're going to use this as proof and evidence of this was the condition when you moved in, and there were no holes in the walls. And we've got in your downloads, we've got inspection forms for each room and Word documents. You can add stuff to it to get some documentation. Take some pictures is another way to get there. Before requiring the signature, advise them, this could be used as evidence. You'd think that they'd be smart enough to know that because they're signing it, but you tell them again, oh, yep, put it right in the lease agreement. Oh, and by the way, the condition statement can be used as evidence to define any damages that may accrue as a result of your abusive use of this, because it can be used by the landlord to determine whether the prepaid rent or security deposit is going to be applied to the payment of the damages when authorized. So we can use it for documentation for that. So to compute the recovery of other damages which they may be entitled to under the chapter. I mean, they could go to jail if they tear it up too much. You could sue them, go beyond. We can go after their permanent funds and some other stuff. Not always worth going there. Action initiated by the party to recover damages or obtain relief, they can use that as presumptive evidence. Here's the form. Here's the pictures, Your Honor. There were no holes in it when they got this place. There are holes now, and here's the damage statement. Get these things. It's a good idea. Make them a part of the contract as well, because then you've got something to fall back on. All right, so we are going to do this little exercise. We'll do it as a town hall. That's what we'll do. For 2 years, Mr. and Mrs. Propagate and their 8 children have rented a 5-bedroom, 10-year-old home with your firm that's had a few repairs. Now, the monthly rent is due on the 1st and late on the 5th. On May 2nd, they give notice. They will be vacating the unit at the end of May. They have a $1,500 security deposit. Final inspection lists the following repairs and costs necessary to rent to a new tenant. 2 cracked windows, $300. Broken screen door, $175. Replace the 6x6 entry area carpet, $250. Carpet cleaning, $200. So, security deposit offset statement. What do you think we can bill them for? $925.
Plus the carpet.
Okay, one at a time. I'm old. In the back.
They need
Okay, they didn't get proper notice, right? Watch it. Watch the date. How many days are in May? 31. An overzealous judge that doesn't like property landlords because they're successful and he's not, he works for the government. You got an uphill battle here. Maybe. Now, they've been there for 5 years. Come on. 8 kids. Give me a break. So, but technically, maybe. Could be arguable. If the judge doesn't like what you did, what are you risking?
I just listened to the outcome of that.
Yep.
The first was on Sunday.
Yeah. Church on Sunday. So, kind of a close call on that. What about the 2 cracked windows? Is that damage or wear and tear? Probably damage. I think that's a fair call. Broken screen door? Yeah, you broke it. Replace the 6x6 entry area carpet. How many years have they been there with 8 kids? They're going to argue, you should have anticipated that. It's 6x6. Come on. So that one would probably be a little rough. Carpet cleaning?
Only if it was professionally cleaned prior to their moving, you have a receipt.
Yeah, and how open is 5 years?
The judge is going to go, yeah, no.
That's wear and tear.
Going to replace it.
Right, or, you're going to clean it or whatever. So, the risk is if they win, you get double damages back.
You have in your lease, they will have it professional.
Widener tried that, turned into a class action lawsuit. They didn't win. So they were giving coupons to people for rentals for a while. After, of course, they drop about 75 grand on fighting it. It's a little bit tough because, I get you can put it in there. It's really good for a bluff if nobody calls BS on it. But the challenge is I'm risking something. I'm exposing myself because if they come back, and that place is spotless. It is pristine. It wasn't professionally cleaned, but the guy owned a carpet cleaning company for 20 years and he still has the equipment. You ain't going to win that case.
Although I just did. So, place looked great. They didn't hire the carpet cleaners. I said, you're going to have to hire the carpet cleaners who professionally clean. Before you move in, it's got to be professionally cleaned. Carpet cleaners go in black light and there's a dog pee soaking a huge area. Now it's a whole lot bigger than just carpet.
A lot worse. Sure. Yeah, so now you got damage, so that they can go at, you can go after that. It's not wear and tear at that point. That is damage. So I think that, that's a pretty safe one. Oh, establishing a property management company. Federal laws affecting rental and leasing. Because here's one that you may not know about. I don't think there are. Well, what about the Gramm-Leach-Bliley Act? What the hell is the Gramm-Leach-Bliley Act, you asked? I'm so glad you asked. I have an answer for you. It is the financial privacy rule. Now, this one is the one that I learned while I was teaching 200 mortgage people how to pass the test. I'm looking at this and I'm going, boy, I'm sure glad we don't have to worry about that. So, well, what is the Gramm-Leach-Bliley Act? It is privacy provisions relating to consumers' financial information. Under these provisions, financial institutions have restrictions on when they may disclose a consumer's personal financial information, and they're required to provide notices to their customers about their information collection and information sharing practices. Now, you'll see the GLBA Act. Back in the old days when they would send us credit cards, they had those accordion disclosures. Usually it was on the last panel. Because one of the requirements is that if I've collected your financial information, I have to let you know what I'm doing to protect that information from identity theft. Okay? Well, it sure doesn't apply to us. And so I'm going through and creating all these PowerPoints. Who does this, anybody that engaging in activity that the Federal Reserve Board has determined to be closely related to banking. Example, extending credit and servicing loans, not us. Collection agency services, not us. Real estate and personal property appraising. I'm not an appraiser, so it doesn't apply to me. Check guarantee services, credit bureau services, real estate settlement services, leasing real or personal property on a non-operating basis for an initial lease term of at least 90 days. That's us. We are doing that. So, what a lot of people don't know is that as a real estate broker, doing sales, I don't have to worry about this. Doing property management, I do. The federal law specifically says is that if you're a property manager, you've got to protect that information from theft. You've got to let people know on an annual basis what you're doing to protect their information. Yeah. Yeah. Nobody's doing this. Not many people are doing this. It's because we don't know. So it's like, now you know. So one of the things you're going to want to do is to consider if you're going to open up a company that's going to do property management, what are you doing to protect the information of other people? Provide an initial privacy notice. know later when the customer relationship is established, are you going to rent this thing? Well, here's the deal. Here's how we keep your stuff secure. Here's how we lock it up. And we'll be sending you a little notification every year with your Christmas card shoved into the middle of that thing. Says, yep, we're still keeping an eye on this stuff, because otherwise you could be at risk if that information gets stolen. And the privacy laws in Alaska, Eldon Mulder told me this. He says, boy, you think that the federal privacy laws are steep. You ought to see the Alaska laws. Somebody breaks into your information as a property manager and starts using that for identity theft, you've got some disclosure requirements right away, or big nasty $100,000 fines start popping up in mass real quick. So you got to be really careful with that. You hire that new person for minimum wage. You go, God, they're great. They're terrific, man. $10 an hour. I never think I'd get somebody this good. As a matter of fact, I drive by at night. They're in here at night too, volunteering, taking copies of Social Security numbers, because they're going to be adios retiring pretty soon. We live in a different world. I went to Hawaii a couple years ago, and I'm heading out, and I'm a bachelor. Sometimes it gets a little messy at my house because nobody goes there. Nobody cares. Abby didn't mind. So I'm looking for this damn duffel bag that I always bring back lots of macadamia nuts with. So I'm looking all over. I can't find it. It's buried under clothes or something. I know, I'll grab my duffel bag. So I go to grab my duffel bag. Well, I was in the military during Vietnam. Back in those days, we used a Social Security number as our service number. I walked through many airports with that duffel bag. No problem back in 72, 73, and 74. Walking through the airports with that now, with my Social Security on the outside, not such a good idea. So, I darkened it out and took it anyways. But, because we live in a different world today. So we got to protect that stuff. So we want to look about the trust account, financial privacy if we're opening up property management or a real estate brokerage. What would be some of the other things that we ought to be considering? Maybe bonds for employees that are handling cash could be one option. Check your E&O. Make sure, does it cover this new stuff? What we know is the RICE policy. Not your own stuff, it doesn't cover, if it's a duplex or above. So check the exclusions on the E&O policy. We were actually able to beat the RICE insurance policy in 60 days with a policy that was cheaper, with more coverage, with no deductible. So we have a source in it, but we have some better vendors that are out there now than just the RICE insurance. So that I can then share that with them. This is the regulations, all of the regulations in the regulations that deal with property management. There ain't 10 pages of these things. That's the whole thing. So as I mentioned, there is a limited amount of information that is available in the regulations that relate to property management. There's not dozens and dozens of pages. Actually, there's only 5 sections in the regulations that relate to property management. And we're going to go through and kind of hit the highlights of all of them, because there's very little in the statutes. It's all in the regulations is where we're going to find the direction that we need to follow in property management. The first section, 64.550, that deals with property management transactions, basically addresses that licensee that is doing property management has to do all of that business underneath their brokerage, the registered name of the real estate company with which the licensee is affiliated. So you can't conduct property management for another person without a written property management contract. And so at a minimum, the property management contract has to include the specific responsibilities of the property manager, the authority and powers given by the property manager to the property owner, and the period of the agreement and the management fee. So those 4 things need to be in there. Subsection C, a licensee acting as a property manager can transfer funds between 2 or more accounts maintained for the same property owner if the licensee has written authority from the property owner. You got to make the entries fully identifiable for each transaction in the ledger accounts, but I am authorized to do that. You can't do that if you're dealing with 2 different community association companies. They've all got to be handled in separate trust accounts. Next, we see under subsection D, any property that is subject to an existing property management or any sale or exchange of the property that's subject to an existing property management contract has to be authorized by specific language in the property management contract or by a separate listing agreement. So it could be combined on one. Typically we're going to do them independently. And then I also, under subsection E, if I own rental property, I've got to disclose in writing to all the tenants and prospective tenants that the property that the licensee, in this particular case the property the licensee owns, also holds a real estate license in the name of the company with which the licensee is affiliated. So that needs to be disclosed so that if there's a problem, they know they've got recourse to not only reach out to the Real Estate Commission, but also call my broker. Next, we look at 64560 that basically addresses that we are in need of complying with the Uniform Residential Landlord-Tenant Act, but this is a very limited. This is a good area where we could look at expanding this so that it's a little clearer that the licensees are working underneath the auspices of the Uniform Residential Landlord-Tenant Act and that the Real Estate Commission has authority. Because what this focuses on is the prepayment of prepaid rents and security deposits, and states that they must be in a trust account as required by the Uniform Residential Landlord-Tenant Act. Otherwise, it's considered fraudulent or dishonest conduct. Now keep in mind, this is a Uniform Residential Landlord-Tenant Act, and 64560 does not say that commercial properties have to be put in, the deposits have to be put into a trust account. If I, the broker, am holding the money, I want it in a trust account because it's somebody else's money. However, in a commercial lease situation, well, and it's true in a residential as well, the landlord could hold the deposits. There's nothing precluding them from doing that. However, the Uniform Residential Landlord-Tenant Act says that if a landlord is holding the deposits, then they have to be kept in a trust account. That's the residential requirement. It doesn't say that for commercial properties. It is not the same requirement. Next, we get into 64570 relative to the property management of real property. Licensee who has sole ownership of rental property could either manage the property through my employing broker, or I could hire somebody else at a different brokerage to manage my properties for me. When I'm doing that, I'm not required to keep the records for files and rental agreements, etc. if somebody else is under the requirement of holding those, if they're being held by somebody else. So, licensee who owns real property described in A of this section also has to disclose to each prospective tenant that I am licensed, as is required under 615A6 through 8, and all the other disclosures, as well as I have to let them know of the conflict of interest and document that as well. I need to also provide the broker with any information on the property owned by the licensee, including any financial records, record agreements, ownership positions, and etc., or percentage if it's an LLC. If any updates occur, then the licensee needs to let the broker know. Maybe there's a change in the ownership, different members of the LLC, so we got to keep the broker informed. Any security deposits held in the broker's trust accounts in compliance have to be held in the broker's trust account. The licensee can have a privately owned trust account as long as the broker has access and oversight over it. And when we're looking at prepaid rent, what we're basically addressing is any money that is demanded by the landlord at the beginning of the tenancy for purposes of ensuring the rent's going to be paid. Doesn't include the first month's rent or money received as security deposit. We also have to provide written documentation relating to any refunds of the security deposit, provide that to the broker as well. Any rent that is paid under subsection C can be paid directly to the licensee because it's their money at that point, and it doesn't have to be deposited into the broker's trust account. The duration has to be in compliance with 88-600, and the Commission can impose a disciplinary sanction for violation of this section under 08-88-460. It's got to be filed by the person if the claim is based on a violation of fraud, misrepresentation, or deceit, or a loss suffered. So that's basically the replacement of the old surety fund with the recovery fund, so there's an opportunity for the tenant to make a claim under those specific circumstances. So if the property is owned by a partnership or a corporation, LLC, or any other kind of legal entity, licensee has to disclose their ownership position to the broker and the ownership entity of the subject property. So the licensees are subject to the section under B2B of this section, making sure that they're informing the broker of their role and make sure that the financial records and etc. are made available for the broker for oversight and review. Section 64580 deals with licensees who perform community association management. So in addition to the requirements, they have to comply with the sections of the statute under 341 and have the delineation of the services that they're going to provide, fees that are going to be charged, the time frame of the relationship between the licensee and the entity, and they also have to provide a consumer pamphlet or disclosure, as it's now referred to, under 12 AAC 64-118. They've got to comply with local, state, and federal laws in the management of the community association management, disclose any conflicts of interest under 0888-391, which include if they were managing a unit in the association as well as the association itself. And if they're collecting funds, they can have control with appropriate approvals relative to the operating account, but they cannot have any control or access to the investment account or reserve account, which is really where all the money is. Also, the responsibility to provide a resale certificate within 10 days of written request. But there's a whole section, 3407 and 3408, both outline under the Horizontal Property Regimes Act and the Common Interest Ownership Act, while a form of property management drills down into much more detail in terms of the responsibilities that real estate licensees have when managing community associations. The Horizontal Property Regimes Act drills in more to the detail when the developer is controlled. It's the older act. However, the Common Interest Ownership Act starts addressing what happens when it has sold over 50% of the ownership as far as the condo association. This is good news for the developer. They want to sell out their project, and once they do not have the votes to control the association, then they have to turn over the appropriate records to the new association management team, that is the board of directors, as they're turning the appropriate records over, which you would presume would be all the historical records, etc., because at this point, homeowners association is going to take control. We're going to take a look in much more detail as far as what the responsibilities are when it comes to managing a condo association and the specific rules and obligations that the real estate licensee is obliged to follow. Oh yeah, I'll get that too. And let me get to that bed bug thing as well. I know Brad is out in remote Alaska right now. He's got the dog that smells them little suckers. You probably both don't need one.
I don't want it.
Okay, a little bugs on this. He's got this really cool little dog that smells those little critters out. I know he's done this in Juneau. He's out in remote Alaska right now. Nice guy. So if you have the need, he's great to call. Association management is a specialized form of property management, and in some cases we have some companies that will only do association management. Some will do property management and association management. Some will do everything: commercial, residential, association management, and property management. The one criteria is, though, because of the conflict of interest under 0888-391, if I am managing the association and, in addition to that, managing units as rental management agreements within the association, then there's a requirement to disclose the conflict of interest. We'll look a little more closely at that here shortly. But so the whole world of association management is found really under the hierarchy of the various importance of the various documents tied to the association. Now we're going to be using the state laws 3407, the Horizontal Property Regimes Act, and 3408, the Common Interest Ownership Act, from which the authority then is defined in terms of setting up an association. So we look at the hierarchy of association control. The first thing we're going to look at is, what does the plat map say? Is there any other sort of a plan that might be out there? Next, when the developer goes to establish the condo association, the declarant or the developer is responsible for providing documentation to the governmental entity that is going to approve the association. This is known as the declaration or the master deed. So it's going to identify what are the conditions relative to any restrictions that might be out there. In addition to that, are there any proprietary agreements as far as leases or other lease contractual elements on the association grounds itself. So we'll take a look at those. Next, the Articles of Incorporation for the association will give us some additional control. They're of a lower level in terms of priority of the earlier recorded documents. Next, we're going to look at the bylaws and the rules and the regulations, and then finally other resolutions. This may be where we actually find the authority within the hierarchy of the documentation that authorizes the hiring of association management companies and the stipulations that go along with that. So if we're going to be then writing an association management agreement with the condo association, what are some of the requirements that we're going to want to identify? So one of them is going to be, what is the authority? That the association is granting authority to the condo association management company, and sometimes what we'll see relative to the handling of monies, there has to be authorization. If I'm going to be handling the accounts, the operating accounts for the association, has to be done with the approval of the association board of directors. Of course, we can't handle the reserve account. That is only reserved for the association. But what authority does the association manager have? Are there plans and warranties that I should be paying attention to, that I'm supposed to be monitoring on things like the heating systems or other major systems within the association? What is the manager's duties? We're going to drill down into this in quite a bit more detail, because very often the nature of our duties is going to be based upon what we negotiated. How much does the association want us to do? How much are they going to handle themselves? And a lot of times it depends on the association. So the manager duties may include what would be my role relative to financial duties. How about insurance and bonding? Am I supposed to be following up to make sure that there's adequate insurance? In the Park Place Condo Association lawsuit, the problem was the association manager recommended repeatedly that you're underinsured, you're underinsured, you're underinsured. Well, they didn't get the additional insurance, and so when the fire happened and burned up a significant part of the association, or the condo association, while at the same time leaving many of the units untouched, they ran out of the insurance proceeds long before they had concluded with fixing all the damages, and the final result was that each of the units, whether they were touched by fire or not, ended up with an $80,000 assessment per unit to pay for the shortage on the insurance. So that gives a tremendous amount of liability to the board of directors. And likewise, as an association management company, if I'm finding that my recommendations for things like insurance are not being followed, it may be time to fire the association, because the cost of the litigation is going to be significantly higher than the amount of money that you would be making from the condo association. So we really need to work with them together, otherwise we're going to create a tremendous amount of exposure for ourselves. So insurance and bonding, maintenance, how are we going to handle that? Sometimes we're going to see that there's inside contractors working in larger associations. I did some consulting work with one where they had their own internal division to handle the 600 units that were in the association. So in some cases, the association management company may be monitoring and supervising in-house people who are doing repairs and maintenance, or they may be administering the contract. So how are we going to handle it in a particular association? And then the resale certificates, we know we have to get those out when requested within 10 days by law. Who's going to handle that? Is that going to be the association management company? Or in some cases, what we may find is that the condo association itself wants to handle that through their treasurer. So we just wanted to find it in writing so we know who's going to be responsible for what. So in looking at the agreement provisions, we want in that contractual agreement, this is a PSA agreement, personal services agreement, we want to define the appointment of our brokerage as the managers who are going to be running this association. We want that language in there. And of course, with the AREC consumer disclosure, this is the point at which of the signing of this or the discussion of this that we would want to do the disclosures relative to the licensee relationship, the AREC consumer. More importantly, now that we have given the disclosure, now what we need to do is address what will our relationship be with this association in terms of our structure. So we're going to be, as I mentioned, identifying any conflicts of interest under 391, and that is specifically if we have some relatives that may also be living in the association, or specifically the stipulation under 391 that says if we're providing the property management services and association management, then the board of directors should know that. We should get a disclosure signed by them defining the conflict of interest. And if we happen to be dealing with a repair that might be necessary in one of the units that we're also doing property management on, it may not be a bad idea to run that by the board of directors or a designated person to assure that when I'm in a position where I'm wearing two hats and making a decision, that I'm doing it transparently and so that everybody can see exactly what we're doing. So we're not favoring potentially one of the landlords within the association whose property I may be managing. It doesn't necessarily have to be a bad thing, the disclosure under 391. You may, in fact, find that other owners of the units within the association may want you to manage their properties for them as well. We just can't give them any preferential treatment when we're both being the property manager and the association manager at the same time. So we need to disclose that. Also, what's the compensation going to be? Is there going to be an override for certain projects? So we can drill into quite a bit of detail here. A collection and legal expenses, are we going to be handling when people fall behind in their dues? Are we going to be interfacing with the association's attorney? What is our authority with that? Certainly every time we pick up the phone, it's going to cost money, so we'll try to limit that to the degree that we can. And then contract administration, outsource contractors, vendors that are being used by the association. Are we going to have a role? If it's time to paint the association, again, the walls, or if we're going to have some roof repairs done, are we going to be directly involved with that? Or is there going to be a subcommittee of the association handling that? And then what does the termination look like? How do we fire them? How do they fire us? Is there a term of this agreement? Are there certain things that, were they to be violated, would call for termination? So we want to kind of define those stipulations. And by the way, in your download materials, we have included sample association management contracts that you can use. They're in a Word document format. You can use those and then modify them easily because those were a project that was done 30 years ago that the Real Estate Commission paid for. And so we've scanned all that information in so that if you do decide to venture down that path of association management, you have some of the basics already laid out because it's a lot cheaper to go to an attorney and say, tell me what's wrong with this 30-page document, as opposed to giving them a 30 pages of blank paper saying, just go ahead and write one up for me. So you do have some resources that you can review. Now, in terms of the accounts, a licensee may not commingle the funds of one community association with the funds of another. So unlike property management, where I might have all of the security deposits from multiple landlords in my trust account, that's specifically precluded when we're dealing with association management responsibility. So we have to put each condo association in a different trust account and not commingle them with any of the licensee's own funds. You may not, within the practice of a community association, exercise control over the reserves or investment accounts of a community association, keeping in mind that the operating reserves are supposed to have no more than 2 months worth of operational reserves. After that, we're supposed to transfer the money into the reserve or investment account. I talked to one of my friends who's an association manager, and that's all they do. And I asked him, how large is the largest reserve account that you have on any of the 90 associations that you manage? His response was about $900,000. So they don't want a real estate licensee to have signatory authority over accounts of condo associations with $900,000 in them. So we're not allowed to exercise control over the reserve or investment account. Only the operating account can we have authority to be able to exercise any control. But there are certain stipulations necessary in order to be able to manage those operating accounts. They include that it has to be approved under a contract that has been signed by the association board of directors. So they know that we're going to be managing and exercising some control over the operating account. And in addition to that, there must be duplicate financial records that are sent to an address not only to the person managing the property, but to another address as well. So they don't want 2 copies of the bank statements being sent to the embezzler. They want 1 copy being sent to the treasurer of the association at a separate address, so that they can kind of serve as a double check. You know, they come to me and they say, you know, Jerry, I saw this at the last on the last budget and the last bank statement. It says that there was a $2,000 deduction, and I wasn't really clear what it was last month, but I see it again. Can you tell me what that $2,000 is? Because I don't remember authorizing a $2,000 expenditure. And I say, well, yeah, that's my retirement plan. And they say, well, we don't remember you signing or getting approval on a retirement plan. I say, well, it's not an official retirement plan, but 4 more months and I'm adios out of here, and I'm living somewhere without an extradition treaty. Because what we've seen is that the embezzlement tends to happen over a period of time, has been the pattern, and then once a certain amount of accumulation has happened, then they're gone. So we need to watch this and make sure that somebody is keeping an eye on those bank statements to be able to serve as that double check against any potential embezzlement. A community association operating account, by definition, is one that contains money for the day-to-day operations. And once we get more money than is estimated to be needed for 3 months, then what happens is we have to transfer the excess into the reserve account as soon as is practical. So we want to make sure that we keep the balance in the operating accounts relatively low. 3 months is the maximum. And that then they transfer over to the reserve account where all the big money is held, so that can eliminate some of the potential for embezzlement. Now, the reserve account is that account that is held for replacement costs and improvements, so that's where the big money is in the definition under 990. In addition to that, under 990, if the board of directors is going to allow the broker to exercise control, then they need to get some sort of additional insurance. Maybe that's a bond or a fidelity bond, to make sure that the association is protected should the licensee or the broker do something inappropriate with the funds, so that they're protected. If the board of directors allows the broker to exercise that control, they've got to provide evidence, as I mentioned, of the fidelity bond that will cover the maximum funds that would be within the control of the community association manager at all times while the bond's in force. They could grant an exemption if there were some other forms of insurance that might be made available that the commission felt would be adequate to be able to cover the association against any potential loss. 4 examples of each of them we're going to take a look at. What kinds of examples might we look at in terms of ways that we could deal with fiscal services or administrative and clerical? We'll take a look at building maintenance, and finally grounds maintenance. So if you're taking this class correspondent, you could stop the tape now, scratch down a couple of ideas on what types of services related to those 4 different areas might include. So take a moment, write those things down for you in the classroom here. We're going to go ahead and do this in an exercise. So in looking at fiscal services, let's see how these ideas might complement the ones that you've written down as well. I could be responsible for paying the bills as the association manager. What about billing and collecting of any assessments? Or will somebody else do that? This is all negotiable. It just sort of depends on the amount of effort that the association would like you to expend running their association and what they would be willing to pay for. So there's no right or wrong answer. It's whatever makes the most sense in the relationship between you and the condo association, because they're all just a little bit different. What about preparing payroll for any on-site personnel? If there are, in fact, on-site personnel or is somebody managing those? Preparing financial reports. How frequently do you want us to pull the P&Ls together to report? You know, when are the meetings going to be? What about budget and reserve analysis? Is that going to fall on the responsibility of the association management company, or are you going to be looking at some auditing capability from CPAs that might want to make a recommendation for you to make sure that when it's time to fix the roof, there's enough money there to be able to do it. And then who's going to be responsible for maintaining the financial records of the association? Am I going to be doing that as the real estate broker, property manager, association manager, or is the corporate treasurer going to be handling that kind of detail and workload? Next, we look at the administrative and clerical areas where we could be serving a role to help the association. Are they going to want me to arrange and attend annual meetings, board meetings, and committee meetings? I can tell you this is one of the burnout areas for many of the people that get into working at brokerages that focus on association management, because very often you may see 50 to 100 associations being managed by some of these companies, which means there's a lot of meetings that these people are going to have to go to. And sometimes, going to those meetings can be challenging and stressful because we've got people that are upset. They don't want to follow the law. They're doing kind of crazy things. And so I've seen generally 6 to 8 months is a very common kind of threshold before somebody burns out doing condo association, and then boom, they're off to go do some other kind of real estate. And the association management company then has to train somebody else, get them their license, and put them out there for a while, because those can be sort of stressful, especially when you got people that don't really know what their rights and responsibilities are, but they have an opinion about stuff. What about maintaining the membership roster, records, and files, or is that going to be handled internally? And then preparing and processing transfer information on resale. Going back to are we going to be handling the resale certificates, or is somebody else at the association going to be handling that? In looking at other things that we could do from a financial perspective, and informational administrative is preparing and distributing the new resident packages. Some associations have them, some don't. Some will have a newsletter. Are we going to type it? Are we going to write it? Are we going to collect submissions? Or is there a newsletter committee within the association or communications group that's going to handle that instead? Preparing for special mailings if there's a meeting that needs to happen or there's a particular issue that needs to be brought forward. What's our role in that going to be? And then often as we see the board shift, new board members are going to need an orientation package. So that's one of the things that we can do as a service, is to put together a package of board orientation, because if I'm managing multiple associations, there's usually going to be some level of churn and turnover. So once I've prepared a really good orientation package, sometimes I'm dealing with some people right now, and we're talking about doing some recordings so that they could actually get a recording that could walk them through what the expectations are so they could be more effective as a board member. And then reviewing the standard operating procedures, because sometimes when you're taking over an association, it has been self-managed. And they may have some antiquated procedures that may be against the law, or there may be some other problems with them that an update could really be beneficial to the association. So taking a look at those, looking at an inventory of association property, what kind of tools, equipment, resources, contracts, etc. do they have, so that we've got a good handle on that. Now when we get into the management services and other things that we could be looking at, is looking at the building maintenance services, and with both internal and outside contractors. Looking at the janitorial, plumbing, and painting contracts that may be out there. Do we have incidental contracts? Do we only do these at certain time periods? Maybe we only paint every 3 years. What are the contractual agreements that we have in place for that? And do we want to be called upon to assist in the selection process, because we're knowledgeable, very often with people that may not be? And then what will be our role in terms of monitoring the performance and work of the employees and the contractors when a job needs to be done? So that can be different depending on what the association is looking for. Lots of work that we can do. What about performing the review of on-site and outside contractors in terms of the ground maintenance, landscaping? Are we going to be setting that up, monitoring it in terms of making sure that the job is done appropriately? What about recreational facilities? Some organizations out there have pools or other facilities. Is that going to be our responsibility? Is there a clubhouse that we're supposed to be monitoring? What if we're renting it out like we are over in Bayshore? Snow removal, the idea here is to be sure to get a contract that is written, that carries within it the standards and trigger points at which when does the snow removal company come out? How many inches of snow, or what are some of the other trigger points that would be necessary to consider? Trash collection, sweeping. You haven't been throwing gravel out there on the ice all winter long. Are you going to come out and sweep all that stuff up so people aren't tripping over it, and there's not to do some dust abatement as well? And then, are we going to hire and evaluate the performance of contractors that are involved with the grounds maintenance, and what would be our role for that? Or do we have somebody there that's already in play? And then, am I expected to provide periodic reports on terms of how the maintenance and how the condition of the complex is? So it's all negotiable. It's all can be put in the agreement. What do you want me to do? We just want to carry an agreement that is clear, that specifies exactly what we're supposed to do, so we cut down on any communication problems that could happen, because the association thought I was going to do something, I thought the board of directors was going to do something, and what could happen if there's a gap between those expectations and something is not handled that should be handled, and it creates a hazardous situation where somebody gets hurt, then both of us could potentially be pulled into the lawsuit, which nobody wants to happen. So understanding clearly what we're supposed to do. So that's about it in terms of some of the key areas that we need to focus on when we're dealing with association management. We have more detail in your handouts and in your downloads that gives you specific contracts that you can use to be able to bring clarity to make sure that if you're going to take on the role of association manager, that you're doing a good job and you're not leaving any bases uncovered. So that's it for today on association management.
How do we access all the different cards?
She's going to send you an email that's got a link right to it with a password and everything on it. You're welcome. If there's anything we can do to help in the future, please don't hesitate to send us out an email and let us know. Somebody's got to gather this stuff up. Might as well be me.